simple example, no matter where you encounter a USB-C port and a USB-C cable, they're going to work together because each one conforms to the standard that was promulgated by a standard development organization. And that facilitates this interoperability, facilitates competition among producers of the equipment, but it also creates a process by which the industry itself determines what are the most appropriate, efficient, desirable technologies to incorporate into the standard. So if I'm going to manufacture USB-C cables, I'm going to be necessarily practicing many patents held by other companies. And the Standard Development Organization may or may not have a policy by which anyone who participates becomes bound to if they're a patent holder, to charge only a fair, reasonable, and non-discriminatory patent, and if they're an implementer, to be responsible for paying no more than that, but be responsible for paying that royalty. Now, what is a fair, reasonable, and non-discriminatory patent or the royalty? That's left undetermined for the most part. There are some companies that will say in advance, if you incorporate my technology into the standard, I will seek the following royalty or royalty rate. IBM's been doing that for years and years. These participants are, for the most part, well, in one sense, the largest percentage of the patents in the standard, and there may be many, many patents. There are about 10,000 patents practiced by this firm. Probably 80% of them, 70% of them, are held by fewer than a dozen companies, 10 or 12 companies. Nokia, Emerson, IBM, you'll recognize all the names. Whereas the implementers are in mobile phone industry, everybody makes a phone, and consumer electronics, that includes many firms that manufacture less sophisticated equipment. So inevitably disputes arise as to what is the appropriate royalty, what is the maximum fair, reasonable royalty, and those disputes have to be resolved. They can resort to litigation. I think in a dozen or so years that this has been kicking around in the U.S., there are only about 60 reported cases of litigation, almost everything is settled, and very few actually even begin litigation. Tens of thousands of negotiations are terminated with agreements without any difficulty. A small number then might go to arbitration, and some or alternatively to litigation. So that about sums it up. If there's a question for clarification, let's do that now. Okay, so we have a clear idea. Keith, would you clarify anything I just said?
I think you nailed it.
Oh, okay. All right, first time, good. First time. Thank you. Okay, well, that said, we're going to proceed through a number of topics that involve issues that arise and that are disputed. Some of them are in the context of private disputes over FRAND, fair, reasonable, non-discriminatory rate, and some of them are public policy issues that arise between jurisdictions. So the first question on our docket is this. What are the various metrics that are used to value and compare, to value the patent and what the royalty should be? For example, out of the royalty rates, fixed monetary amounts per unit sold. It's been a practice in the mobile film industry from the beginning, for instance, that the royalty will be calculated on the basis of the number of phones sold, as opposed to the number of times that my patented component appears in the phone. It just turns out to be easier to monitor phones sold, and so for reasons of efficiency, it's not 100% accurate, but everybody agrees that's the way to go. rather than spend time identifying what specific patents are in a particular phone. So let's get some conversation going on this question of the various metrics that can be used to determine royalty rates.
All right, so you mentioned mobile phones. For practical reasons, the way licensing of mobile phones has been on the basis of, initially it was on the basis of the wholesale handset selling price as being a royalty base, and then the royalty rate as a percentage. And that was actually, that suited both the licensors and the licensees. Particularly the licensees, I would say, because when the first licensing came during the 2G era, handsets were costing still, even though they were basic handsets, they could only do voice calling, they couldn't even do text, but they were still costing many hundreds of dollars, up to $1,000. But the whole industry knew the price was going to go down. So a fixed dollar per unit licensing fee would not have been very attractive to the licensees. So we went through that era, I think, for probably a decade or so. Everyone was kind of happy with that approach. But then what happened with when we came to 3G and into 4G, the average selling prices of handsets started rising again. And then there was a lot of capabilities in the phones that were beyond voice and text. And then there was pressure, certainly from the licensees, not to be paying a percentage of the wholesale selling price, the entire wholesale selling price. So then we started to see a switch. To some extent, it was one was to have a royalty cap or a cap on the royalty base. So a handset selling price cap. So, for example, InterDigital today has a cap of $200. So if there's a handset that's sold for $1,000, for example, and InterDigital's headline royalty rate for 4G, I think, was 0.5%. It actually means the effective royalty rate is 1/5 of what it would be on the entire
CPU owner, in view of end product makers, they are free from SEP patent, but component maker is not. Why? When component maker is to deal with another end product makers, they have another problem, right? Chip makers are, component maker is not free from one end product maker's license with SEP owner. SEP owner got the freedom, but not component makers. Okay? In that sense, so many, multi-component makers are having the same problem. And also, supply agreement-wise, normally, component makers are giving patent indemnification to end product makers. We cover everything. Whatever things you will have a claim against the final product, component makers will cover completely. That's the reality. So in that sense, let's say that we accept that and the product will cover the component makers. What that means, component makers are paying the royalties to the SCP owner, beer, and the product makers without knowing the detail about the agreement, terms, royalty rate, whatever things concerned about their chips, their component. That's the problem, right? If component makers are doing the same continuously, is that okay? They don't have to organize their IP department. They don't need to have an IP expert in a company. They don't have to prepare for the future IP wars. That's the serious problem. That is the most serious problem. by doing, entire unit price royalty will make the whole society healthy? I don't think so. So they will really weaken small and medium companies or component companies' IP position, weaker and weaker, and there is no protection at all. So component will not become a big company. SME companies will have the same situation. So I believe that there are some arguments, even if court decision-wise, right? There are good bases that SSPPU is better royalty base from, laser dynamics, and also innovation case-wise, court support that. Of course, there are many cases that take the position the other side. So it's a big, competition, looks like. But if we work in IP society, we have to make the whole IP society worldwide healthy, and we need to IP market grow in the future. If we see the big pictures, I believe SSPPU is the better royalty base for calculating, the royalties. That's my understanding. I will, explain more about global license and the regional license together. Okay?
Did you ever say what SSPPU stands for?
I didn't say that. Wow. I will explain to you about what SSPPU means. That's the smallest saleable pattern practicing unit, which means that is component in my explanations. Usually, pattern covers either component or sets, systems, whatever the pattern claims covers, right? But this case-wise, the claim covers only the smallest sellable pattern processing unit, which is components, what I'm saying. I don't know if you understand that or not. If not, you can ask further.
Yes, we should pause for a second to let you ask questions or seek clarification or whatever. Start.
And practicing the method. So, for a same patent holder, it has to go for method claims to the device manufacturer or the end product, and for the same apparatus claim within the same patent, you have to go to the SSPU because the SSPU is not practicing the method. So, from the efficiency of the licensing, don't you think it's better to go for the end product licensing for these different types of claim sets in the same patent?
Yes, of course, there will be some gray area. This invention goes to the component side, or this goes to the set product side. It depends on how they negotiate. It can be resolved, but the main issue is whether the types of component licensing is better for the society, or end product licensing is better for the society. The whole society-wise, I'm taking the position that component licensing is better. And also, think about these issues. If we have a certain issues about royalty rate matters, we talk about the running royalty and fixed amount, but in advance, there are also certain issues that, Qualcomm, they explained during the discovery, they confessed that if they would put a charge on the set instead of components, that will be much more lucrative. They can make more money. And judge accepted that. Judge agreed. if you put a certain royalty on the set, that is much more lucrative. That's one thing. And another thing is think about potential licensors in smartphone area. How many, potential license in that area? Let me calculate. Not many, like Nokia, Ericsson, Qualcomm, perhaps InterDigital. Say, just few number of potential licensors. They are covering all of 100, maybe 100. I'll be exaggerating a little bit, but 100 component, makers. Which means there are 100 component makers taking the position. That means that doesn't take care about the another world, court system, patent system, regulators. It really, give a certain harm to another jurisdiction, right? Of course, court will say that, well, if I will decide in this way, another country judge will say different way, it's all up to that jurisdiction. Is that okay? Then there will be so many different determinations and decisions, court decision will come up. Normally they will not do, even if they are allowed. Just like, EU. EU is trying to set up the unitary patent court, IP court, but it's not going well up until now. But if there is a unitary court that covers the whole world, that's fine. If not, let's say about the patent. Patent will be registered in each territories. Indian patent must be registered here in India, not UK, not US. So those patents registered in US cannot cover Indian territory at all. Even if the SCP owners, they cannot file the same number of patents, same number of corresponding patents to India at all. They will pick up some of the most important countries. Thinking about the market of cellular phone, right? US and EU is big market. They file, SCP patents to US, EU first. And next they will think of the rest of the world. India is important. If they don't think important, just a few patents must be filed in India. And different legal system will say that, oh, that's not patentable in view of the prior and public knowledge in India. Well, there are a lot of issues, different decisions will come out from Indian Patent Office. So there must be invalid, not enforceable during the course of examination based on inequitable conduct, a lot of things. So, considering that, if a coerced global licensing style be, pushed, then it will create a lot of issues for other areas. So what I'm saying is that just like go into a separate license agreement, we have to consider territory issues seriously. Let's say that one component makers, they are selling their component to US only. Well, think about the current environment, US versus China, big, hassles about their power regarding, chips, semiconductor. So, other than other allowed makers, they cannot sell their, product to China at all. Even if so, right? So considering that, why the component makers, they cover the whole world instead of covering only that company is manufacturing. Supposing that Korea is Korea only, Japan is Japan only, that's fair. If they will pay the whole market, royalties on behalf of end product makers, that's unfair. what they have to pay to royalties for end product makers. That's not good. So, to make, global licensing must be allowed means there must be based on the voluntary basis, right? That's important things. Unless the component makers will choose global licensing, pattern, component licensing must be allowed. Just like the menus. We need a menu that shows SSPPU style licensing and also end product licensing styles, so that any potential license can choose either way. That only shows the transparency and also very fair to the whole industry. Think about SSPPU and global licensing together. If, the SSPPU and global licensing issues must be regional licensing matters considered, it will give a very irreparable damages, harmful damages to component makers and also small and medium makers. They have no chance that their business will grow to the wall. That's my analysis. I think there will be some questions.
Yeah, one more. I get very uneasy when I hear people talking about fairness.
Since you touch upon the native patent code, right, in your market specifically, so how basically it's affecting nowadays there is a lot of debate ongoing with respect to whether the licensing should happen rightly or not. Specifically, if I talk about in pharma segments, but it is generally applicable to the other segments also. So now the innovators or the inventors are more willing to do the licensing, considering there is a nationalized system that is going to be placed in one place. Previously, it was the case, sometimes they have the top hinge in the mind that certain countries, okay, we will be giving rights, certain countries we won't be giving the rights, considering there is a national threat with respect to the litigations, and where there is a high chances of getting the patents invalidated if someone is challenging. Instead of getting the right royalties at the right time, is the beneficials for the entire organization, or as well as the inventors. That's what. So that's what I would see in coming time, that whether if there will be any SEP makers or any SEP patent holders, right? If they are fighting with respect to those patents specifically in the European market or any other countries, right? There will be high probability chances that since the system is placed, the Unified Patent Code system is placed, there may be chances for the declining of this royalty rates, or there are the other possibilities that will be coming out from this. Thank you.
We wish that Dr. Kim, what you suggested could happen, a global kind of arrangement. But I don't think that is something which we foresee right now. It kind of disputes are there around, and particularly when we talk about intellectual property, it is territorial in nature, and there are a number of dimensions to it. On your SSPU point, which you pointed out,
Correctly, but in my opinion, IoT matter, ICT, whatever is connectivity issues, as I mentioned earlier, there will be some gray area, which means that, let's say that the smartphone will control all of your domestic home appliances in a remote way. Okay? So that goes into some part in smartphone, so that there will be some communication, sending signals here. There must be some recipient area on the device at home, right? Through communication only that works. So which component or which system will enable to communicate efficiently and work that function? So it goes to the functionality issues. If it covers as a whole equally then you have to think about the value of each part. So how to claim the invention covers a certain portion of each devices or not, right? But normally, it's been manipulated by this mobile phone. The core technology will be processed here. Might be. Then, if you will disregard a little tiny portion of the inventions, instead, you will focus on the major inventions that's incorporated into mobile. That will be enough, in my opinion, in my analysis. But the big core technology incorporated into each of your home appliances, then that devices, must be treated separately, which means the royalty goes to each home appliance rather than this mobile phone. So it depends on each case by case. I cannot say as a whole, this will be the best way to do. That's all I can answer to your question.
Thank you, Mr. Kang. Professor Singh, did you want to add something?
Yeah. You want to say something?
Sounds like we're back on the SSPPU topic, my favorite topic. Another issue related to IoT is, there's a very wide range of applications. A particular chip might end up in a device that might use the technology once a year, or it might end up being central to that particular device. So how licensing based on the chip makes sense in that case? How can you, just from the chip, foresee what the value is going to be to the end product?
Well, I talked about mobile phone, as an example. Let's say that it doesn't, work relying on the mobile phone, but instead it's been, controlled by a certain chip in a mobile phone. Then we have to consider that major chip separated out of mobile phone. That's what I'm saying. So mobile phone was just an example, like a major component incorporated into mobile phone. I don't think all of multi-components work together. Maybe, one major component will play that kind of role.
I'd been hoping that we were going to move on from SSPPU. I just want to add one comment. It's conceivable it might be worth having a 5G light bulb. There might be some value in doing that, but for sure it's got to be extremely cheap. So the chip that is put in, it may have a range of capabilities. It may be convenient to have the same chip that is connected to the light bulb as connected to the brain scanner or the remote surgery technology. There's clearly a lot of price difference between the two applications. There's a lot of value difference between the two applications. I think as Sven was saying in his question, if you're shackled to the SSPPU approach, you're hitting the lowest common denominator. And that economically is a problem. It's economically inefficient because you're down at that level and you're then going to discourage, and it's worthwhile economically encouraging people to do the development that enables the more sophisticated applications. But if you're always shackled to having to price it in a way that makes it accessible for the light bulb market, then I think that's a problem. Because if you're down, you may end up with no one's willing to sell it at a price that's viable for the light bulb. So you lose that part of the market, or the one size fit does not fit all is the major challenge in doing it at that level, and that's why the market has evolved in a different way.
There may be some instances where it makes sense to have a price, for example, for a module, and you don't really know where a module is going to go. It can be very difficult to control. Maybe you can control it and you can have some price differences. Maybe you can't. But to have a sort of blanket exclusion from being able to do what the economists call price discrimination, which is generally regarded as healthy economically. I think not being able to do that is a problem. The problem with discrimination is it's gotten very bad connotations in over the last decades. It's to do with all sorts of use of the word in the common English language, and including in the use, for example, in the term FRAND, the notion that it's bad to discriminate. There can actually be some good discrimination. There can be some economically efficient discrimination. And in that case, I think that's what we've seen so far in pricing, and I think for there to be a sort of mandatory approach to having pricing at the chip level or the SSPU level is problematic. And the other colleague who asked the question, I think that was a very good point as well. Actually, in terms of infringement, it isn't all in the chip anyway. And the other thing I would just say, there was one judgment which I think is defective. Sorry to critical of the US judges, but in Motorola versus Microsoft, the notion was the damages were set on the profitability of the chip manufacturer. I take this is a bit simplistic, but I think there is something in it.
Bring the company to court to actually try to enforce your patents, looking back and applying the exact same rate is actually an incentive to all that. Because if the worst that can happen is you're going to pay the same price at the end, if your royalty, if your sales are fairly large, it's worth actually going to court, taking your chances. If you're lucky, you might not pay as much. And if you're not lucky, you pay what you should have paid in the first place.
Yes, this is an issue that arises also in connection with whether a patent holder who cannot get an agreement with the licensee should be able to get an injunction against further infringement or an exclusion order against importing the product, the infringing product, into the jurisdiction. And periodically, the United States administrations have taken the position that it should not, injunctive relief should not be available to the patent holder on the ground that it deprives the public, consumers, of competition with that product included in the marketplace for a period of time, and let it all get sorted out later on, and then collect royalties based on the period of the infringement. But it's the same problem. The incentive then is to hold out, not sign up, let yourself get sued. The worst that can happen is you have to pay the FRAND rate, whatever the jurisdiction determines as the FRAND rate. So it's a position that the U.S. administrations have taken, the current one and the Obama administration, which in my view makes no sense whatsoever, especially considering that just because a person seeks an injunction doesn't mean that they can get an injunction. And indeed, one of the criteria for getting an injunction in the U.S. and in Germany and elsewhere is that you will not be able to collect damages later on because the company would be, the infringer would be financially unable to pay at that point, or it's a marginal company to begin with. So if you don't get paid now, you risk not getting paid ever.
I think it's appropriate that the market responds by having the licensing arrangements that are, if you like, sympathetic to that. And I think that as we start to think about devices other than phones, so far we've mostly spoken about phones. Once we start talking about the licensing for a car, I mean, the rhetoric from back, I can remember Vodafone when LTE was about to come in, maybe 2007, 2008, and they were asserting that there's one company out there that would think that the royalty base should be the entire value of the car. And they never said the name of the company, but they were implying that it would be, for example, Qualcomm. Qualcomm never said that. I've never come across anybody in the industry who seriously would be suggesting that the royalty base for a connected car would be the entire value of the car. And what has happened, we have a licensing platform for cars, and it's $1 per unit price. And that's a very logical way to go. So, summary, I think that we shouldn't be dogmatic, and I think the problem the judges, my concern about the judges, they're very smart people, but they have quite a narrow focus sometimes on the case that's at hand. And when they make a statement like one approach is discriminatory, inherently discriminatory, I think it's a dangerous way to go, because the market needs the ability to be able to respond to the conditions as the market develops.
Well, I appreciate your empathy for judges. Because they do have to decide something to resolve the case, whether they want to or not. And they try to avoid saying never or anything else that's so definitive that doesn't allow for evolution, but sometimes they do. Keith made, we'll turn to Mr. Kim in just a moment. Keith made a reference in the licensing negotiation to holdouts. So I just want to explain the terminology, because this has become the subject of a great deal of academic debate and some litigation. In the negotiation between implementers and innovators, between manufacturers, say, and patent holders, you encounter allegations that the implementer is not willing to take a license. It is refusing altogether to take a license and pay for it, or it is using delay tactics to avoid entering into a license agreement. And these allegations come from, of course, from the patent holder side of the equation. Or you get complaints from implementers saying that the SEP owner is holding me up. In other words, demanding a royalty rate that is unreasonably high. Empirically, there's very little that we know about this situation, because there are thousands of these negotiations all the time. From what we know in the economics of bilateral relationships, among recurring parties, and these are overwhelmingly repeat players, we don't have problems like that because of the reputational harm, because of the desire to participate in future technologies. But nonetheless, there are interests that pay consultants to make arguments along these lines and to litigate along these lines. Yes.
If I may, and I don't want to delay the whole thing, but I've been accumulating a few points I didn't want to interrupt. With respect to fixed amounts per unit versus percentage, we operate mostly in the smartphone area, and we understand that for the same wireless connectivity option, you can have different phones, and sometimes from the same vendor, different phones with different screen sizes, different battery sizes, but effectively exactly the same wireless connectivity. So if our patents relate to wireless connectivity, it doesn't quite make sense to charge a higher price for a phone that has a bigger screen. So we charge a price that's based on a unit royalty, a fixed amount. But still we're getting pushback from phone vendors that are making feature phones saying, well, we don't want to pay the same royalty as what, for instance, Apple would be paying for the iPhone. So, I mean, it's really hard to come up with a solution that is going to satisfy everybody. I don't think there is such a solution, but I think some of the things that Keith mentioned, I think, address these issues. Another thing that I wanted to that I noted is that there was this issue of lump sum versus running royalty and the risk associated with trying to extrapolate the rate or extract the rate from a lump sum agreement. I think that was, I just wanted to give one example of that. There was a case in China where InterDigital was litigating against Huawei, and they went back and looked at the lump sum agreement, and because the timing was such that the lump sum agreement was signed around the time that Apple was coming up with the iPhone, so nobody knew, if that was going to be a success or not. There was a lot of risk on both sides. Apple didn't know if it was going to be a success. They didn't want to pay a large amount, and on the other hand, InterDigital didn't know if that was going to be a success. They was trying to get a bigger amount, but at the end of the day, they made some assumptions at that point, and by the time it got to the court over there, looking back at the agreement, 5-10 years later, they concluded that the lump sum amount divided by the actual sales of the iPhone was the royalty rate for this agreement, which doesn't quite make sense because they obviously didn't know that the iPhone was going to do so well when they signed the agreement. So that's the danger of looking at the lump sum agreement and trying to reverse engineer a rate from it. I think you have to put yourself in the shoes of what was the data available when they signed the agreement versus what is the data available now about what they could have done for this agreement. And lastly, we did touch a bit upon signing agreements with, even in the case of a running royalty agreement, a lump sum for past sales. Obviously, we won't have time to cover it, but I'd like to raise the problem that if the same rate is applicable for past sales and future sales, there's a bit of a disincentive for potential licensees to sign up early. If you cannot ask.
Thank you, Keith, for that explanation. And one point which I note from your speech is that what we see in terms of litigation is only a fraction of it in the FRAND and SEP regime, because a lot of things gets negotiated which doesn't come before because that is working perfectly fine. And that is something which needs to be brought forward. That has to be told to people that this is happening, and this exactly happens with one of the dispute resolution mechanism which we call mediation, because you never come to know as to how many mediations got settled or how many negotiations got settled. You only come to know about the litigations which are covered or brought forward. So that is definitely a challenge. There are a couple of points which I would like to bring it forward in terms of this point. That is how do laws and public policies vary internationally on FRAND rates. Now, this is a question which we have also, discussed since morning. We have been talking about this, and different parameters have been told, either it is top-down approach, or you go ahead with the SSPU mechanism, or you go ahead with cumulative mechanism. But whatever may be the mechanism, it will be jurisdiction specific, because we have seen these things being brought up in the courts. And one of the major challenges I can speak about India is that we don't know which authority will be deciding it. So, people have been going from one court to another court, and there have been litigation live. People choosing for a better forum where they will get the relief from both sides, either the implementer or the patent owner or SAP owner, and that is what is creating problems. So there has to be a clarity in terms of the authority who will be dealing with it. Now, there's a question whether we want this clarity or we don't want this clarity. We want to leave it to the market. There's a question which needs to be deliberated upon. And Keith, thank you for your paper in which you have examined the European Union and US perspective of it, where they have proposed for an agency which will be looking at the SEPs, because there are questions which are coming up because there will be stacking of the patents which may not be relevant, but still they are considered as part of SEPs, and royalty is based on those patents as well. So these questions will come up. But in India, if I look at it, there are some litigations which has happened, and the latest one which Delhi High Court decided was with reference to this Ericsson case. And if we see the decision, you don't get a concrete answer as to determination of SEP, because it has not given the formula at what should be the SEP, because it is difficult to determine as to what would be the SEP. And I recollect some of the decisions of the Commission in which experts were appointed. This is not relating to patents, but definitely there was a requirement of an economic evidence, and two set of economists presented reports which were contrary in the same case. And that has happened because the petitioner will be coming up with their economists and they will bring up their perspective. The respondent will be coming up with their perspective. Now here the question is of public interest as to what should be the fair, what should be the reasonable decision in this case. And for determining this, none could be better than the parties themselves. So there has to be a neutral agency, that is what is my understanding of it, who can actually discuss it out between the implementers and SEP. Probably the standard setting organizations, if we are looking at, they may have some mechanisms around it where you can have the discussions and close this. This is one of the way forward, because this is a grey area, not yet any solutions found there. In terms of the standard setting organizations, if I look at India, there are a couple of them. Like for example, we have Bureau of Indian Standards, who set the standard on particular products. In terms of railways, we have RDSO, Research Design Organization. They set the standards for particular products, which has to be utilized in the railways. Now, one has to also look at these agencies, because I recollect one of the cases in which the Competition Commission of India said that you cannot set the standards too high that there are no more players, or there are only 2 players who could bid for this particular contract. Then it becomes a problematic situation, because you are then reducing the competition around it. So different places would have definitely different mechanisms to deal with, but there has to be some commonality or common platform which should come up. In this case, there was also a point came up which you referred to, Mr. Douglas, is about anti suit. So that was the first kind of an injunction which Delhi High Court also gave, because there was a case which was filed in Wuhan for getting the injunction, and then the High Court said that no other country's court can put an injunction on our jurisdiction as to whether we will deal with it or not. But similar kind of a thing is happening in insolvency bankruptcy, if you look at it, where we are talking about cross-border insolvency mechanism. There the principle works on a similar platform, because there what you are doing is, if any of the court takes the jurisdiction over the asset of the insolvent's asset, then the other courts don't look into that particular matter. The jurisdiction or the principal seat for the insolvency proceeding remains the first court in which it comes. Can there be a similar kind of a situation in the IP and FRAND disputes? These are some of the questions which I have just brought forward, which intrigues me as a researcher and a professor of law. So to the House and to my fellow panelists. Thank you.
Thank you. But what we can consider or view, what we can forecast on the future aspect, on the similar lines. Let's say it will take, the examples of how the drug discovery process going on in the pharmaceutical area. So whenever any, the brand companies or innovator companies come up with the new molecules in the market, they usually file a series of patents, which are a key content, like say what we are discussing in the SEP's areas. There are the apparatus patents, there are the chips patents. The similar way, there are the series of the patents with respect to the compound, how to use those compounds, what kind of the compositions are inside those the products is there. Right? Those are the key constraints patents for anyone who wants to come with those products in the market with those molecules. So what happens actually, right? In US, let's say if we talk about the US, there is a clear system, so there is a stringent system that there is an R&D book where you have to listing down all these patents. So that maintains your standards, and which has been governed by the FDA, so everybody. And there are the standard sets by the FDA to what kind of the patents that you can be listed what kind of patents that cannot be listed. Right? So whenever any generic companies are going for developing, or you can consider any infringement rights, those who are developing the alternate product to bring the cost-effective products in the market. So basically, at that time, there is the litigation starts. So in that areas, there may be a chances for so many of the. Now, when we talk about the licensing matter in that area, so sometimes it depends on what kind of product is there and which therapeutic segments and how much patient populations they are targeting throughout the countries. If it is the rare therapeutic indication area, or if it is you can consider the diseases for which very few of the molecules are approved, or there are not so many companies are interested in doing the research there. So there may be chances of high licensing or the high royalty for the brand company if someone wants to bring the cost-effective medicine. But if in case of let's say if I'll talk about the diabetic segments, or if I'll talk about the cardiovascular segment, there are lots of companies are working on that segment, right? Because that's a very prevalent throughout the professions, and so many out of 10 people you will see the 8 of them are suffering from these situations, right? So there may be a chances that you will not get much the licensing fees or much of the royalties, because basically in pharma, whenever any licensing happens, it may be between 10% to 30%, depending on what kind of the products that you are selling. Now, if we will talk about coming to the India markets or any other countries like Europe markets or Latin America market, there won't any existence of such systems. Right. There are the key standard patents or key constant patents in that area, but there are no standard patents or standard systems or guidelines where So what happens it starts the litigations out of those the process or out of those the agency process, and whenever there is because see the standard patent is always everywhere, because brands has invested a lot of money, usually billions of dollars they have invested in those. So they always want to go more than 100 countries, more than 150 countries at a time, because they wanted to have the global protections in that, right? So when it comes to the other countries part, right, there are the out-of-court litigations, or there are out-of-agencies, litigations where, the key constraints patents on which, the brands wants their rights, right? These are the key constraint patents, which no one can bypass or which no one can do, right? And for which we want either the royalties if someone wants to come in the market, or they should be the protected. But at the same time, if you will see, there is a system in India, right, which is called as compulsory licensing, right? Because at certain times, what happens, right? In standard essential patents, since we are discussing about the royalty based, the scenarios, or if you want to bring, some alternative cost-effective UI in the market. So here it is the same scenario is there, the cost of the therapy is so high, it's not affordable to everyone, right? So there is a system side, you can bring after certain years of the times, let's say if you cannot manufacture or if you cannot provide the cost affordable medicines to the patient, right? There are the systems that you can bring, or you can apply for, the certain cost effective, the licensings to the countries. So that is a one type of system existence in this country. And at the same time, what we see in the future, there may be chances for application of these SCPs into the pharmaceutical areas also, because there are nowadays, if you will see, there are so many innovations going on the platform technology aspects, right? And specifically, if I tell the raw materials, the API parts that we are calling, or any other let's say any the technology-based product which no one can make. So what we see in the future, right, let's say, since there are, if we will talk about the trends analysis of the each disease segment, right, there is a sharp rise in last 10 years, right? Whatever the patients that were affected with the diabetes or the cardiac segment, there is a huge rise in last 10 years everywhere in the world, right? So what companies are developing going on the platform technology part also, right? By which they can provide the cost affordable medicines. So in that cases, we can see the future that there may be chances for to bring this, the SCPs as well as the FRAND license. Right. Thank you.
Professor Singh, did you want to comment?
From this, one point which Mr. Agrawal pointed out, one thing emerges is about essential facility, and that was one of the points which also comes up in this FRAND, and there's a thought which I that whether these particular SEPs can be considered in the long run, or maybe if you, as an essential facility, and they say that, okay, fine, you need to grant an access to this on fair and reasonable terms, because that is an essential component or an essential technology. Like say, for example, you have talked about USB, or a similar kind of a technology if in future it comes up, and can it be considered as an essential facility and granted access to, like a compulsory licensing, as we talked about in drugs? Can it be possible in case of mobiles or similar kind of a technology, or maybe we are launching into EVs or similar kind of an area? Maybe one technology is said that it is essential facility, or the principles of essential facility doctrine under the competition law. So that is one point which I had just to bring for.
Let's turn to questions, comments, and so on from you all. You've heard a lot. You have a lot of expertise here available to you to respond to